Good afternoon to all of you tuning in on the East Coast. Good day to all of you who are here from elsewhere. You might have been expecting to see Kristen Smith. I am stepping in for Kristen. Kristen had an unavoidable conflict, but of course sends her regards to all of you, and she'll be back later this month. I have the pleasure of walking you through what will be another interesting and timely program. If Kathy, you'd go to the next slide, I can tell everybody what's on tap. But first and foremost, I'm hopeful that all of you are staying cool. I know that in many parts of our geography, it is really, really hot right now. So please take care, be safe, and certainly we are in the midst of summer. There's no question about it. So let me go through the agenda. As I mentioned, first, after I conclude, we'll be hearing from Paige Carey out of our New York City office. Paige has been on the program a number of times before, and she'll be talking about a decision that comes out of the Third Circuit that has really interesting implications for college athletes. And so more to come there. Matt Wells will be making his first appearance on our program. Matt is based in our Syracuse office, where he's a member, and he focuses on public finance and will be addressing various issues concerning bonding. It should be really interesting background for those of you who have less exposure to an important topic than perhaps you should. Devin Karras is back on the program, also out of our New York City office. He'll be addressing what's new in employee benefits, including a look at how Chevron, that case I talked about and that we heard previously about from Nick Jacobson, which is really seismic, essentially the undoing of it, as it were, by the Supreme Court in recent weeks, how that affects employee benefits, because, as we've been indicating, the implications are really myriad. And then Lance Willoughby Hudson, who also is out of our New York City office, whose office wall is directly adjacent to mine, as it were. Lance will be talking about employee handbook do's and don'ts. And so we're glad to have Lance back on the program as well. So without further ado, let me introduce Paige. Paige is known, again, to many of you because she has been on the program a few times over. Paige is an associate who focuses on employment, also has a healthy dose of institutions of higher education in her practice area. And this is a topic that really fits within that overlay of the two. And so, Paige, we're delighted to have you on the program to bring this audience up to speed on this important activity out of the Third Circuit. Paige, please go right ahead. The floor is yours, and welcome back.
Thank you so much, Gabe, and good afternoon, everyone. So just a little bit of an outline and overview of the presentation today, which focuses on the case which recently came out of the Third Circuit. It's called Johnson versus the NCAA. And the overarching question of this case is really the issue of whether college athletes can be classified as employees under the FLSA. And then following a brief overview of the context of this case and its procedural history, we'll head into an outline of the decision itself, and then talk briefly about the collateral issues and case impact. Next slide, please. So just going to breeze through a bit of context before getting into the case itself. Since 2021, we've seen many successful challenges to NCAA rules regarding compensation for student athletes, particularly at the D1 level. One of these notable advancements is the case in the Supreme Court that was in 2021, NCAA v. Alston, which many people have heard about this case. In a nutshell, it ruled that the NCAA rule prohibiting payment for name, image, and likeness of athletes violated antitrust law. And in making this holding, the court recognized that college sports is a profit-making enterprise, and it rejected the NCAA's definition of amateurism, which referred to the fact that athletes do not receive remuneration for their athletic services. Another very notable advancement in this area is General Counsel Bruzzo's memorandum on the status of players at academic institutions. And what this memorandum, in a nutshell, again, concluded is that students who engage in intercollegiate sports at private colleges are employees under the NLRA. Next slide, please. So taking a bit of that context and the advancement of kind of different cases and memos chipping away at this issue, we then come to the case Johnson versus the NCAA. This case was first brought in 2019 by 6 former NCAA Division I athletes, and they asserted claims under the FLSA and various state wage laws against the NCAA and the student athletes' respective universities and institutions. Specifically, the athletes claimed that the NCAA and the member institutions had violated the FLSA by failing to pay them at least minimum wage for their work as members of teams. And they were members of a variety of teams. There was football, baseball, tennis, swimming, many different teams. So the NCAA and member schools then moved to dismiss. They asked for dismissal on the grounds that the students were amateurs. So again, trying to hinge on that definition of amateurism and not professional athletes, and therefore the FLSA did not apply. Ultimately, the trial court refused to dismiss the case and rejected the NCAA's amateurism argument. The court analyzed the student athletes to interns and used a test articulated by the Second Circuit in the case Glatt versus Fox Searchlight Pictures Incorporated in order to determine whether the student athletes were protected by the FLSA. And just kind of briefly going over this test that was articulated in Glatt, the Second Circuit had created a 7-factor test to determine the economic reality of the relationship between the interns that were involved in the Glatt case and the entities that they were working for. And under Glatt, ultimately, the trial court in Johnson determined that student athletes might be employees. After this decision, the NCAA and institutional defendants appealed, again arguing that students were amateurs, not employees. And this appeal was an interlocutory appeal, just quickly important to note, because it appealed the dismissal rather than appealing the outcome on the merits. So there was no conclusion as to the merits of whether these employees were whether these student athletes were specifically considered employees, but it was possible under this test. Next slide, please. So on appeal, the Third Circuit put together a 3-judge panel which affirmed the district court's denial of the NCAA and member schools' motion to dismiss and identified that the frayed tradition of amateurism was no shield to the FLSA claims. Specifically, going back to the Alston case that we mentioned earlier, or that we discussed earlier, the Third Circuit cited that the Supreme Court's decision in Alston, which again, as a reminder, stated that amateurism was not an appropriate reason to gain an antitrust exemption. It was improper for them to now use this amateurism argument in order to obtain a quasi-legal status in the way that was rejected in Alston. Next slide, please. However, ultimately, the Third Circuit panel also vacated and remanded the district court's decision for application of a different test to assess the athlete's employment status. The Third Circuit identified that the Glatt test was not the proper test because Glatt arose from matters involving unpaid interns, which were not analogous to the facts that are involved in that of a collegiate athlete. So specifically, Glatt's overall utility was undercut by the presumption in Glatt that was accurate when related to interns, but inaccurate when related to student athletes, that all unpaid interns perform work for their employers. The panel identified that there was this distinction between work and play with student athletes, and that any test under the FLSA must be able to identify athletes whose play is also work, which interns in that were at issue in Glatt did not have that specific factual distinction involved. So instead, the panel created a new test that was based on NLRA precedent, which specifically identifies that college athletes can be employees under the FLSA if they perform services for another party, necessarily and primarily for that party's benefit, under that party's control or right of control, and in return, they receive express or implied compensation or in-kind benefits. So this was then remanded to the trial court to analyze the issue under this new test. Next slide, please. Just briefly, important to note that one of the judges on the panel did join in the outcome of the case, but not in its reasoning. A couple of specific points that this judge made that caused his disagreement with the reasoning was that he believes that the court should not have agreed to hear the appeal until trial, or at least until full discovery had taken place. He also noted that the trial court and the Third Circuit both did not distinguish between the different circumstances of the range of Division I athletes, and stated that it wasn't just about football and basketball players. It was about players of all different types of sports. And this can come into play because, as many people may know, football and basketball are primarily the money makers in the sport. So there is a little bit of a distinction there, which causes a bit of a fray in the facts. And then he also stated that the majority's test did not adequately probe the distinction between play and work, or explain how district courts going forward should do so, and that this left some open questions, such as, is serving on an intercollegiate athletic team player work, and does this differ by sport? Next slide, please. So ultimately, what is kind of next in this development as to whether collegiate athletes can be considered employees under the FLSA is we aren't sure quite yet. It's likely to be several years before we have an answer to this question. And this case or another will probably end up at the Supreme Court because the stakes are so high, which just to note, the stakes are high for a variety of reasons, but at the forefront of this is if players are deemed to be FLSA employees, they'd owe, the NCAA would owe at least minimum wage for their labor, and these players would be eligible for overtime pay. So the NCAA could be, in the long run, ordered to pay many millions of dollars in unpaid wages and forced to amend amateurism rules in order to recognize an employee-employer relationship, which further erodes that principle of amateurism that the NCAA continues to rely on in cases such as Alston and this case here. And so, as I mentioned, unlikely to see a development quite in the near future, but we will be sure to keep you apprised as to developments once they become available and updates become available. But for now, student athletes are not entitled to compensation under the FLSA, but this could change. And this case itself really demonstrates the possibility for that change. Thank you.
Thank you so much, Paige. Really great presentation, important update about a highly topical issue. And of course, as we learn more, particularly concerning the cases remanded, please come on back to the program because we'd love to ensure this audience learns about those updates along the way. But for now, let's turn to our next speaker on our program today, and that's Matt Wells. Matt is the chair of our firm's public finance practice, and he's a business law attorney who focuses on public finance and commercial lending, does a lot of work with tax-exempt organizations, school districts, universities, hospitals, etc. I've had the pleasure of working with Matt a bit myself in the overlay between the work I do in healthcare and the implications vis-a-vis Matt's practice. Matt has not been on this program before, though, and we're delighted to have him on because Matt is prepared to walk through essentially some highlights regarding what bonding is, what it isn't, how it relates to all of you. Some of you may really not know the first thing we recognize, others may be deeply enmeshed. Matt's goal is to give everyone a sense of what his practice area is about and what some of the interesting issues are. So Matt, thank you so much for taking this time. Welcome to the program, and the floor is yours.
Thank you very much, Gabe. I'm happy to be here, making my initial foray into the business webinar series. So thank you. And as Gabe mentioned, I'm a member in our Syracuse office and have been at Bond, Schoeneck King for about almost 20 years. In addition to being chair of the public finance group, I'm also chair of our recruiting committee, among other tasks now. But getting on to my topic, it is going to be a rather high-level overview of bonding. Realize that many participants don't have a lot of experience in this area, so I want to just give a general overview, kind of cocktail party conversation, if you will, to give you some of the basics. So, what is public finance, and when does it come into play? When institutions or entities are thinking about financing capital projects, improving their physical plant, or refinancing outstanding indebtedness for interest savings or other reasons, we are involved. From our public finance practice group perspective, the majority of our transactions and our clients will involve municipalities, school districts, and oftentimes 501c3 entities, healthcare entities like Gabe was mentioning, hospitals, higher ed. We do quite a bit of higher ed work representing colleges and universities with their financing needs. Um, Obviously, our overall firm's capabilities in lending go far beyond just public finance. But for purposes of this discussion, it's going to be a discussion that largely relates to tax exempt financing by municipalities, school districts, and 501c3s. Um, in terms of talking about a deal, usually like to start off by explaining some of the phases of a financing transaction to folks. Um, and those phases we like to break down into 4 or 5 different distinct phases. Number one being a planning phase, where typically architects, engineers, facilities, personnel, and the financial team and the CFO typically get together to see what capital needs an institution may have, what type of financing may be required. Do they need to borrow? Do they have enough funds on hand to take on a project without going and borrowing money? But in the event that they do need to borrow money, that's when the lawyer's role becomes more prominent, and we will help out with the authorization phase, we'll call it. And during that authorization phase, we'll help you through some of the regulatory issues that you need to deal with. For instance, the State Environmental Quality Review Act, or SEEKR as it's known, is something that needs to be considered for any project that's taken on by a state or local issuer. And as I'll get into a little bit later, 501c3s can't borrow or can't issue tax exempt bonds on their own behalf. So they use a state or local issuer as a conduit issuer. And so SEEKR is nonetheless an issue for their borrowings as well. And then we'll also help out with the actual bonding authority, the bond resolutions that are involved there. Next phase is the financing phase, where the borrower will determine whether they want to enter into a short-term borrowing or a longer-term borrowing. And then after the borrowing, another phase is the post-issuance compliance phase, where if you've issued tax exempt or borrowed tax exempt proceeds, you do need to worry after the borrowing occurs that you continue to comply with the tax rules and what are known as continuing disclosure rules after an issuance. So want to tell you a little bit also about the parties to a financing, and they're a little bit different between the municipal side and the 501c3 side, but a lot of similarities. So you will have an issuer or a borrower. Again, municipalities and school districts can issue tax exempt bonds on their own, so they'd be both the issuer and borrower. A hospital or a college, they're going to need a state or local actor, so they're going to be the borrower, and they're going to utilize what's known as a conduit issuer to issue the bonds on their behalf and then loan them the proceeds. You'll have what is known as bond counsel, which is a specialized area of the law where law firms act as bond counsel to make sure that bonds are validly issued, and they'll give an opinion to that effect, and their opinion will also discuss and cover the tax treatment of the bonds, whether they are eligible for tax exempt treatment. So a very important role. You'll also typically include an underwriter and their counsel on a transaction. Interestingly, on the municipal side, or what's known as the general obligation side, the underwriter kind of comes into the picture as during a competitive bidding process, whereas with the 501c3 side, the underwriter and the 501c3 are negotiating earlier on in a negotiated purchase context. You'll have rating agencies that can be involved, Moody's, Standard & Poor's, Fitch, that can give ratings to bonds, that can create better marketability for the sale and hopefully lower interest rates if they're involved, or a better ability to sell and market. You'll have a bond trustee on 501c3 deals uh, um, that would act as an administrative function on behalf of bondholders and administer the payment, if you will. They'll be a paying agent, and they'll take repayment of debt service by a borrower and then distribute it to the individual bondholders. Auditors will be involved in terms of putting together audited financial statements that can get included in a disclosure document, or what we typically refer to as an official statement or a prospectus. You'll have financial advisors, and if you have a refunding, you'll also deal with escrow agents that hold money and then will use that money to redeem bonds. So basics and terminology. What is a bond? Well, bond is really just an evidence of a debt. So it's very similar to a promissory note that a bank would require a borrower to sign in connection with a commercial loan. So it's just evidence of an obligation to repay a debt. I alluded to a governmental bond. So munis and school districts, they issue a governmental bond, and they issue it backed by their full faith and credit, their taxing power. Whereas 501c3s don't have that taxing power. They issue what are known as conduit bonds, and they're known as revenue bonds. And the repayment will be based on some type of a loan agreement structure where the borrower will agree pursuant to that loan agreement to make debt service payments of principal and interest and other expenses. And so, good distinction between general obligation for our muni and school districts and revenue for a 501c3. There are similarities, but there are very important differences. In terms of types of financings that are out there, you could have fixed rate versus variable rate bonds. Fixed rate, as the name suggests, you're going to have a fixed rate of interest for either a period of time or through the entire maturity of the bond. Very similar to a mortgage for those of us out there with a mortgage, that fixed rate of interest for 30 years typically. Variable rate will reset itself based on a predetermined formula at periodic intervals that are negotiated. You could have a tax exempt loan or a taxable loan. Tax exempt, the borrower or the bondholders do not have to pay taxes on the interest earned, and so they like that, and it usually will lead to improved borrowing costs or lower interest rates that can be available. You can go, at least for 501c3s, you can just go to a bank and get a commercial loan as well. That would typically just be a taxable loan. In New York State, municipalities and school districts can't do that. You have to be aware of that for anybody on the call that's muni or school district. You can't just go to the corner bank, and you have to really follow the New York State Constitution and local finance law when determining how to borrow, and use bond counsel to help you out. And there's also publicly offered bonds or privately placed bonds. Public offering, as the name suggests, goes out to the investing public. It involves a disclosure document that's rather extensive, an underwriting marketing effort, etc. Whereas private placement is with a individual bank or a group of banks. Why choose tax exempt when you're eligible for it? It can be very efficient and effective financing vehicle for larger projects. It's quite complex, so it is more expensive if it's not a larger project. If it is a larger project, tax exempt can lock in significant interest rate savings that can save a borrower quite a bit of money. Smaller projects for 501c3s, you're really not going to consider it. Whereas again, munis and school districts, you can borrow tax exempt even on your small deals, and that's what will happen typically. It's a lower cost of capital, but it is complex, as I mentioned. Uses of tax exempt bond proceeds can be for new money projects, refunding or refinancing to lock in savings, or in much more limited circumstances, working capital. The IRS doesn't like the use of working capital, proceeds for working capital for various reasons. The authorization process for municipals, you're going to have to deal with the New York Constitution, the local finance law will help you out with a borrowing resolution and the steps through that process. You may have referenda requirements. Again, I mentioned the seeker compliance. a 501c3, you're going to similarly want to have your board adopt a borrowing resolution, and potentially other needed resolutions, including a reimbursement resolution that allows for reimbursement under the tax laws. But you'll also have to consider a conduit issuer and their process and their procedures and their authorization process as well. So I see I'm bumping up against time, so I don't want to belabor it. I told you it would be a very quick overview. There's so much to cover, but I'll offer it to Gabe to cut my time just in the interest of all the participants and our other panelists.
Well, let me just say, Matt, thank you so much for that really thoughtful overview. As you point out, there is so much to cover in your practice area. And for those of you who, by way of Matt's presentation, have a taste of what it's about and wish to learn more, of course, contact Matt or anyone else within the practice group. We're here to help. And Matt, of course, if there are discrete topics you'd like to present upon on a future webinar, please come on back. And again, thank you very much for today's content. Let me turn to our third speaker then for the afternoon, and that's Devin Karras. Devin has been on our program several times previously, of course, and is familiar to most of you, I would assume. And Devin, in his practice, focuses on a variety of employee benefit matters. As senior counsel, he looks in particular at qualified and non-qualified deferred compensation plans, defined contributions, and defined benefit plans, among many other relating topics. And today, as I noted in my introductory remarks, Devin is prepared to talk about Chevron and its rollback, as well as a few other hot topics within the vein of employee benefits. So Devin, welcome back, and the floor is yours.
Thanks, Gabe. Hi, everyone. Yeah, Devin Karras here again to present you all with another rousing edition of What's New in Employee Benefits. Before I kick off, though, I just want to remind and encourage you all to feel free to reach out to me or Gabe if there's a specific employee benefits topic you'd like me or any one of my esteemed colleagues in the employee benefits practice group here at Bond to address in any future Tuesday presentations. There's, quite frankly, at the moment, there's kind of a dearth in content that needs to be discussed in the employee benefits realm. So now is a good time to put in your questions or topics that you'd like to see addressed in future weeks. So with that out of the way, as Gabe mentioned, one of the topics I'm discussing this afternoon concerns something you're probably all somewhat familiar with at this point, and it's the Supreme Court decision in Loper Bright versus Raimondo. That case was decided in late June by the U.S. Supreme Court, which overturned longstanding precedent established in Chevron versus Natural Resources Defense Council, which established that when a court is reviewing federal regulation or sub-regulatory guidance that interprets a statute, if the statute's silent or ambiguous, the court must generally defer to a federal agency with that subject matter expertise with respect to interpretation of that statute. So for those of you with employee benefit plans or experienced employee benefit plans historically, since Chevron, courts have had to defer to one of the three relevant agencies that helps interpret the ERISA statute. So previously, prior to Loper Bright, the DOL, IRS, and PBGC interpretations of ERISA, which includes the Internal Revenue Code, those would have to get essential, deference, of course. As you know, those ERISA is very broadly written, as are the regulatory and sub-regulatory guidance that's been issued since ERISA was established many years ago, which we're celebrating the anniversary of this year, as a matter of fact. So continuing on, so in Loper Bright, the Supreme Court held that this agency deference to the DOL, IRS, or PBGC for interpretations of ERISA violates the Administrative Procedure Act. As according to the court, when the best reading of a statute is that it delegates discretionary authority to an agency, the role of a reviewing court under the Administrative Procedure Act is to independently interpret the statute and effectuate the will of Congress. not effectuate the will of the federal agency. What this means is that courts, not agencies, are tasked with independent judgment in determining the meaning of statutory provisions, although the courts may always still seek aid from well-reasoned or long-standing interpretations by agencies. So, as I'm sure you might be aware, you're probably all aware of that background, but the purpose of me noting this is to point out that for those of you with employee benefits, so much of what governs employee benefit plans and executive compensation plans is regulatory or sub-regulatory in nature. So for those of you that are familiar, I mean, it's not the ERISA statute that's so voluminous. It is the constant churn of regulatory and sub-regulatory guidance that is interpreting ERISA. It is just constant. ERISA is probably one of the most regulation-heavy statutes on the books that's out there. You know, it seems like although now summer months it tends to slow down, it's like almost every year or every 3 months, there's new regulatory or sub-regulatory interpretation of ERISA that we all sort of have to scramble to adapt to. So the Chevron decision, I think, well, with other practice groups, it may not be as consequential. For those of us in the ERISA space, it is extremely consequential, especially in light of how much regulatory and sub-regulatory guidance occupies the employee benefits space. So with that said, and being aware of how regulation heavy ERISA is, almost immediately after Loper Bright was decided, several attorneys general in several states sent a letter to the Fifth Circuit asking the court to invalidate a DOL fiduciary rule from earlier this year on the ground that the Department of Labor lacks statutory authority to introduce certain ESG factors into retirement plan investment options. As you might be aware, ESG becoming a factor into investment options for a retirement plan has become, it's now a factor that needs to be considered, or that can be considered when offering an investment option under a retirement plan. And this is just one example of probably many examples that we're going to be seeing in the months and years ahead that speaks to kind of the pushback that we're going to be seeing from regulations interpreting ERISA. So, I mean, it's an understatement to say that things are going to get spicy from here on out in the employee benefit space. And with that in mind, we just want to be kind of mindful and vigilant and diligent when it comes to guidance that comes out from the DOL, IRS, or PBGC, because the presumption will be that there will be pushback going forward. So with that out of the way, something that's probably equally important in my mind, and for those of you online that have pharmaceutical benefit plans or prescription drug plans, last week the Federal Trade Commission announced that it's going to be filing suit against the nation's 3 largest pharmacy benefit managers, also known as PBMs. The 3 PBMs under scrutiny are OptumRx, Express Scripts, and CVS Caremark. The FTC alleges that the PBMs at issue engaged in improper pricing arising from negotiations with drug manufacturers that resulted in increased costs for consumers. So as an example, the PBMs are alleged to have negotiated higher rebates with drug manufacturers in exchange for the PBMs giving drug manufacturers products preference on PBM formularies, which again are used by employers to pick and choose those drugs that are going to be offered to health plan participants. In addition, in exchange for these higher rebates, PBMs are alleged to have excluded competing medications on PBM formularies, or requiring patients to try and fail a preferred medication before trying a competing and possibly cheaper brand that's listed on the formulary. These are practices that are not necessarily unknown, but the FTC has come around and alleged that these are unfair trade practices. And ultimately, the lawsuit's likely, well, the particulars of the lawsuit are, at least at this point, not known. The lawsuit is likely to allege that the PBM agreements with drug manufacturers regarding the negotiated rebates and other factors are based predominantly on profits to the PBMs rather than on what's the best interest of consumers. So for those of you in attendance or listening later, with prescription drug plans that use PBMs to help negotiate lower drug costs and administer your prescription drug plans, this is something very much worth keeping on your radar. And this announcement regarding the lawsuit comes just days after, actually last week, or the week before rather, the FTC issued a pretty comprehensive interim report scrutinizing FTC practices as essentially establishing these huge conglomerates with massive influence on independent pharmacies and drug manufacturers. And they're basically kind of almost like, for lack of a better word, kind of bullying the field or occupying the field when it comes to prescription drugs and pricing negotiations. They're just these huge siloed organizations with vertical integration with, they can be an insurer, a pharmacy, and a negotiator all in one. So that report came out 2 weeks ago. And the purpose for me noting this is that, again, those of you with prescription drug plans, it might be worthwhile for those of you using OptumRx, Express Scripts, and or CVS Caremark to ask your PBMs how they anticipate this litigation affecting your PBM contracts that are already in place. It might be a good time to review those if you have any. Hopefully, if you've got PBMs, you most likely have a PBM contract. So it might not be such a bad idea to pick up the horn and call your representative over at the PBM to say, hey, what can we expect out of this? What's going on here? So both of these are monumental, as most things happen to be in the employee benefit space. So that's sort of, the scope of my presentation today. I don't know if I'm above time or over time, but I'm just going to kick it back to Gabe now to keep things rolling along. So
thank you. You are right on time, Devin. Thank you again for your presentation, for those highlights. You're right, those are absolutely hot topics and well worth this audience's time. And so let me turn now to our final presenter for the afternoon. And Devin, of course, please come on back anytime you wish. But for our last presentation of the day, we have back on Lance Willoughby Hudson. As I mentioned, Lance is also in the New York City office, as I am. He's an associate who works with employers on workplace issues and addresses labor and employment law in his practice, among other topics. And a fun fact about Lance, in a previous career, he was also an actor before going to law school. So I have the pleasure of, again, sharing an office with Lance, and he's a terrific neighbor, let alone attorney. Really glad to hear, Lance, what you have to say about important do's and don'ts within the employee handbook space. I know this is an area that you work in regularly with clients, and I look forward to hearing your tips. The floor is yours.
Thank you, Gabe, and hello, everyone. I hope everyone is staying pretty cool. I know it's pretty hot. I won't take too much of your time. I'll try to be really quick about just some of the top things about our favorite thing to review, employee handbooks. But it's very important that you take it seriously and consider some of the considerations. Next slide, please. So the number one big thing is do not copy and paste a template. Templates are good just for a reference point, just to get an idea of just format and like certain things that you want to make sure you cover as far as like policies and regulations. But you have to keep in mind that depending on where you get the template from, it might be a totally different structure. For example, you wouldn't want to use, a corporation would want to use a template from a nonprofit just because they have different business needs and just the language is a little bit more different. And another thing too is like you don't want to use a template from a company who has like primarily remote employees, and you're a company who has employees who come into the office every day. It just changes the dynamic of the handbook. And it's also important too because a template might have different processes that is completely different than what you want for your organization. So I think it's important for employers just to really just, of course, look at a template, but you have to go through it thoroughly just to make sure what works for your company and what doesn't work, and just fine tune it so it can make complete sense for not only management, but for your employees as well. Next slide, please. And another thing you want to stay away from is being over prescriptive with policies. So you want to try to, just to be in general, you don't want to make it sound so legally technical. You want to just make sure the policies are kind of in layman's terms so employees can look at it and kind of understand and not be even more confused about a policy. Because most of the time, employees are looking through a handbook after their orientation just to see what policies would apply to them in certain situations as it relates to like taking leaves of absence or for tardiness or performance review. So you want to make sure the language is very straightforward, and you don't want to have sections or paragraphs where employees are just more confused when they come to human resources to ask questions about any type of policy. And also too, you want to try to just cut out stuff that's kind of common sense. You kind of have to use good judgment on that, but you have to keep in mind that your employees are pretty good and pretty smart. So like this common sense stuff may not necessarily need to be included in the handbook, and it probably could be eliminated just so it won't add to any type of confusion of it. But just overall with the prescriptive policies, just make sure it's not just so technical where it's just confusing for any employee. Next slide, please. And another big thing is, and this kind of goes towards just disciplinary strategies and procedures, you want to make sure you have enough discretion for management to make decisions. You don't want to try to put every single situation in a handbook that might cause disciplinary action, because just given the nature that we are in right now, novel things happen where, you want to make sure you have that discretion to handle the situation. For an example, you don't want to have a policy where it says if you do only X, Y, and Z, then you get an option to have a disciplinary proceeding. But if someone does something that's just so egregious and just is beyond any type of behavior that's acceptable for the company, you want to make sure that that person knows that it is limited. They could also be terminated for that behavior, and they're not necessarily given that right to have a procedure to go through to address that behavior. And also too, as I see in the slide, you also wanted to give that disclaimer as well too, just to make sure that employees know that just because the handbook says that you have an option to go through some type of process of review for your behavior, it can also lead to termination as well. Next slide, please. And this is probably the biggest part of everything that I want to address today. You want to make sure that you include legally required policies. So I know most of the audience are based in New York, and if you're not familiar, there's a requirement to have certain sexual harassment language in your policy. And New York State has like a model that all employers are required to use just to identify what qualifies as sexual harassment, where sexual harassment can take place. The procedures for filing the complaint either internally or externally. And if I'm not mistaken, at the top of my head, I believe they give you external places where you can file a sexual harassment complaint, either with the Division of Human Rights or with the EEOC. So that's just one example of like something that's required to be in a handbook, and employees must have access to it. And other things as well too, like paid leave policies within New York State and New York City. And also too, more recently, which went into effect last month, is paid lactation breaks. That's just something that went into effect, I believe, June 16th, where employees must be paid when they need to take lactation breaks. So you just want to make sure that you have all required policies in the book, either locally or state or federal. Next slide, please. Oh man, I think this is the biggest one, and I'm just going to say that some people are better with this than other employers. You should check your handbook regularly just to make sure it's up to date. I've had situations where employers haven't updated their employee handbook in 10 years, which is pretty crazy considering that typically within the state or locally, laws are enacted that would affect employers. One of the biggest things that I see that happens is like an employer starts with like a certain amount of employees. Let's say maybe it's a smaller company and there's like 10 or 15 employees, but then maybe over the course of a year or 5 years, it expands to over 50 employees. And now at this point, you need to review your handbook because now you have to implement new laws that employers with 50 or more employees must have in place and must give disclosure and notice to employees about those rights under the law. And also too, I just mentioned it, but laws change constantly, not so much with the federal laws, but you will always see new laws enacted for state and local reasons. And that's pretty much it as far as just like some of the do's and don'ts. But I think the biggest thing is just make sure you tailor your handbooks to the needs of your employees and just make common sense revisions and just have it straightforward so it won't come off as something that employees like are afraid to look at, but they actually are interested and is straightforward and clear about what they can do to get answers to questions.
Lance, thank you. Really helpful to walk through those do's and don'ts and your experiences in your practice, I think are really telling. It's important for folks to stay on top of this and to ensure that, for instance, in particular, if the size of their organization changes, they make adjustments that align with those kinds of shifts. So we are at time for today's program. So with that, let me advance, or Kathy, if you wouldn't mind, please advancing to the next slide. Actually, I didn't do the SCOTUS roundup this week, but you can reach out to me if you have questions generally, of course. And the contact information over there is for all the other attorneys. If you'd like to reach Lance, you can also reach out to me and I'll make sure you have his email address. If you have any questions at all around content, any recommendations for what we might cover, we really appreciate those. As you heard from Devin, we're always looking to make sure this program is tailored to what you're interested in hearing. I'll be back with you next week to host, and then later in the month, Kristen will be back with you. I look forward to seeing you in a week, and in the meanwhile, do your best to stay cool out there and stay safe.